My name is Daniel Carter. I'm 54 years old and own nearly 20 acres bordering the Pine Ridge Estate subdivision in Colorado. My family has owned this ranch since my grandfather bought it in 1972. The subdivision came much later. Developers built luxury homes next door about 4 years ago. The HOA always acted as if they ruled the entire valley, but they only control their subdivision, not my ranch. I kept cattle, maintained hay fields, paid my taxes, and stayed out of everyone else's business. That should have been enough. Apparently, it wasn't. The trouble started when the HOA announced plans to build a new community recreation trail. Residents loved the idea. The proposed walking trail would circle a small pond and connect several neighborhoods. There was just one problem. The shortest route crossed almost 60 feet of my property. They sent me a letter asking if I'd donate an easement. I politely declined. That strip of land contained my irrigation line and equipment access road. Giving it away would create endless problems. I thought that ended the discussion. Instead, it only made them angry. Over the next few months, strange things happened. Survey stakes appeared on my land. I removed them. More appeared. Workers occasionally walked across my pasture taking measurements. Every time I asked who hired them, they simply said, "The HOA." I reminded them they were trespassing. They always left, but they kept coming back. Then came graduation week. My wife and I flew to California to celebrate our daughter's achievement. Before leaving, I checked my gates. Everything was secure. Our ranch manager watched the livestock from another section of the property. I never imagined anyone would begin construction while the owner was hundreds of miles away. But that's exactly what happened. When we returned, I couldn't believe what I saw. Heavy equipment sat inside my pasture. Excavators had scraped away topsoil. Wooden forms outlined a concrete path. Stacks of gravel covered my hay field. Nearly 400 feet of fencing had been removed. Several mature cottonwood trees had been cut down. Workers had already poured part of the trail. I slammed on my brakes. My wife simply whispered, "They didn't." Oh yes, they did. I walked directly toward the construction crew. Who authorized this? One foreman barely looked up. "The HOA. This is private property." He laughed. "We've got permits." I asked to see them. He refused. Instead, he pointed toward a woman wearing expensive sunglasses. HOA President Karen Mitchell. She walked over with complete confidence. "You finally made it home." "What is this?" "Our community trail. On my land." She folded her arms. "The board voted. This benefits everyone." I never agreed. "You didn't need to." I almost laughed. "You think an HOA vote transfers ownership of land?" She smiled. "Our attorneys handled everything." Those words would come back to haunt her. I immediately called the county sheriff. A deputy arrived within 30 minutes. Karen confidently handed him a thick binder. She insisted the project was fully approved. The deputy listened carefully. Then he asked one simple question. "Can you show me the recorded easement?" Karen flipped through dozens of papers. Meeting minutes, resident petitions, architectural drawings, construction contracts, but no easement, no deed, no signed agreement, nothing. The deputy looked at me. "Mr. Carter, do you authorize this construction?" "No." He turned toward Karen. "Then this appears to be a civil matter." Karen smirked. She believed that meant she could keep building. She was wrong. Very wrong. The next morning I called my attorney. Within hours he discovered something shocking. The HOA had submitted construction plans using an outdated subdivision map. Someone had incorrectly highlighted my property as common HOA land. No one from the county planning office compared the map against current property records. The permit should never have been approved. That mistake changed everything. My attorney made one phone call. The county's chief building inspector personally visited the site. Construction stopped instantly. Inspectors walked every inch of the project. They checked property lines using modern GPS survey equipment. Within 20 minutes, they confirmed the truth. Nearly 400 feet of the trail sat entirely on my ranch. The permit was invalid. The project violated multiple county regulations. One inspector quietly said, "This is a disaster." Karen interrupted. "We'll fix the paperwork." The inspector shook his head. No paperwork can legalize construction on someone else's property. Bright red stop work notices appeared everywhere. The contractor shut down immediately. Concrete deliveries were canceled. Equipment was ordered off-site. Workers packed their tools. Residents gathered along the street watching everything unfold. Karen kept insisting there had been a misunderstanding. The inspectors weren't interested. One asked, "Who instructed the contractor to enter private property?" Every finger pointed toward Karen. Then the environmental inspector arrived. Removing the cottonwood trees required permits. None existed. Stormwater controls had never been installed. Excavation sat dangerously close to an irrigation canal. The violations multiplied by the hour. Each carried significant financial penalties. The contractor looked physically sick. He admitted the HOA assured him all approvals were complete. A licensed surveyor completed an official boundary survey 3 days later. The results couldn't have been clearer. Every inch of disputed construction belonged to me. Not 1 square foot belonged to the HOA. The county revoked every permit associated with the project. Then they ordered complete restoration of my property. Not partial restoration. Complete restoration. The HOA hoped insurance would cover everything. It didn't. Insurance companies generally refuse to cover knowingly and authorized construction, especially when board members ignored written objection from the property owner. My attorney obtained emails during discovery. Those emails were unbelievable. One board member warned, "We need Daniel's written permission." Karen responded, "He'll complain no matter what. Build first." That single email destroyed their entire defense. The lawsuit moved quickly. Photographs, survey reports, inspection records, property deeds, email evidence. Everything supported my case. The judge didn't hide his frustration. He asked Karen, "Did you believe your HOA could vote itself ownership of private land?" She remained silent. The courtroom was equally quiet. Everyone already knew the answer. The final judgment was devastating. The HOA paid for complete demolition of the unfinished trail, replacement of every removed fence, restoration of damaged pasture, professional soil rehabilitation, replacement of mature trees, attorney fees, engineering expenses, survey costs, and additional damages for trespassing and property destruction. The total exceeded $1.8 million. Residents weren't happy. Monthly HOA dues nearly doubled. Several homeowners demanded Karen resign immediately. She refused, until the next election. She lost by a landslide. The entire board was replaced. The new leadership visited my ranch personally. They apologized, not because lawyers told them to, because they genuinely understood how badly the previous board had behaved. 6 months later, my pasture looked healthy again. New fencing stretched across the property. Fresh cottonwood saplings lined the creek. The irrigation system worked perfectly. Cattle grazed peacefully. The only reminder of the entire ordeal was a framed photograph hanging inside my office. It showed a bright red county stop work sign planted directly in the middle of the HOA's unfinished trail. Whenever visitors ask about it, I smile. It's expensive artwork. Then I tell them the story. Ending. Some HOA forget they're responsible for enforcing neighborhood rules, not rewriting property ownership. A vote cannot replace a deed. Confidence cannot replace the law. And building first, hoping to ask permission later, can become one of the most expensive decisions an HOA will ever make. If you enjoyed this story, don't forget to like, subscribe, and share for more unbelievable HOA battles where property rights always have the final word.